it's going or not, though.
Okay, so in Section 2, we're dealing with the Americans with Disability Act. And you've got a few different cases here. You've got the Casey Martin case, which was a case from a few years back. You've got the medical school approach. You've got a business situation in Toyota. And then you've got the EEOC, Equal Employment Opportunity Commission case versus Waffle House. And then finally, one of the things on the topics here was remedies and domain name lawsuits. And I'll start with that. From the standpoint of domain names and the like, a domain name is www.coin.com. So if you're going to find a location, that obviously is what you call a domain name. And there are, as part of our modern remedies, there are a lot of different things that you won't go to court at all on, and one of them being if there's a dispute with respect to the use of a given domain name. I also use this opportunity to start to have you guys start to think about the use of your own name, if that's what it is you want to use as a lawyer. So whether it's www.attorney.Derek, what's your last name, Derek? Buckley.com or something along those lines, you should start to think about, and we look at it a little later down the line as well, for you to start to think about, well, what is it you would want if you were when you start to practice, and maybe as you start to think about marketing and the like, you should think about what that domain name is so people can readily find you. I think you'd be surprised at how inexpensive a lot of those names are. I actually waited too long, so I couldn't get Michael Coin. I think I've got Michael L. Coin. But if you wanted Attorney Wheaton or whatever it is you want, you might want to start to look at it, and frankly, you waste more money on a bar on any given, even a Thursday night, than you would to purchase a domain name for 2 years, even if you just park it for a while. The fact is that it's about $20 for 2 years. So Attorney Tiller would look awful nice up there, or kellytiller.com. But you might want to think about it. Gary, why did you shake your head?
I already looked years ago when I went.
And it was gone already?
Yeah.
Yep.
Yeah, a lot of Wheatons out there, believe it or not.
Oh, yeah. Oh, yeah. TG, you might be okay. But the point is simply to think about looking and to try and start to think about marketing as well. It's not just about acquiring your knowledge, acquiring the knowledge, or passing the bar, or whatever else, but it's time to start to think about where we go from here. And what this is important is that, you know, at some point you have clients, and the clients, one of the significant ways that they both market and distribute and sell their product these days is by way of the web. And so it won't be surprising to me, it shouldn't be surprising to you, that at some point you will have cases of this sort where you have to proceed with respect to trying to protect someone's intellectual property or defend it against, you know, one of the giants out there that says your client or you are using a name too close to theirs as the website, and now they want it back. So it's important to know and look at those things. And what I want you to start to think about from this standpoint as well, and this is the other reason it's here, is that there are many modern statutory or contractual remedies that you agree to when you enter into these arrangements. And so you have to become more familiar with the remedies that may be available and what rights you have. And in this case, you are likely going through arbitration or the intellectual property court down in D.C. To resolve any types of disputes that originate from that in that capacity. But let's talk about the Americans with Disability Act and the cases that are here. Yeah.
Can I just add something?
Sure. Absolutely, Gary.
I did a paper on this. Basically, this be careful with this article, and I know Professor knows this. This article is very old.
Yes.
1999, the Lanham Act was expanded to get rid of what they call cyber squatting. Mm-hmm. This guy, what's his name, did. So what you'll do now as a lawyer is, as Professor indicated, you will litigate through that using the new Lanham Act, which will help you for bad faith. Bad faith cyber squatting is what they call it. You can get damages now, which you couldn't in this article. And there's two things you want to look at. It's called the it's ACPA, Anti-Cyber Squatting Consumer Protection Act. Is another one that's what expanded the Lanham Act. And the UDRP, which is Uniform Domain Resolution Policy, which is how you'd resolve it. Here it was going through Network Associates. Now it's through an organization called ICANN, ICANN. So that's what you'll be litigating through now instead of bringing it to court. But you can still go over the court route, but it's a lot more expensive.
And the key will turn on whether what a cyber squatter is. There's no problem with buying a name, holding it, and hoping, like a good piece of real estate, it'll appreciate over time and you'll make some money. There is a problem with acquiring Pepsi.com and expecting that Pepsi's going to buy you off for it. Obviously or not obviously necessarily, but you should understand that the trademark holder, obviously under the changes in the Act, has superior rights to anyone else. But that should be relatively understood. But that doesn't prevent the variations of it. I had someone call me. They had a 3-letter domain name that could be what a large insurance company calls themselves at times, or it could be just simply the abbreviation for his company name that he got it before they got it. And so we might first talk about purchasing it, but if the price is too high, then the adversary may well say, well, you're cyber squatting, and now we've got both litigation and everything else that flows from it. So you need to know how this all works. And these articles are older at this point, but you need to recognize that there's a process there that's likely to be well outside of court. And as Gary points out correctly, not without some peril for the potentiality for damages here. And that's the problem. Well, that's the problem generally as a lawyer. You have to be thoroughly knowledgeable so that you can at least educate your clients about their risks in going forward. And especially, if we're litigating against large companies, they will have no problem pulling out those serious threats and telling you that if at the end of the day we prevail, we are going to take the name as well as hundreds of thousands of dollars from you in both fees and damages. And as long as your client understands the risks, and as long as you have educated yourself that you think you have a sufficiently meritorious claim, there's no reason to back off. But a lot of companies, as much as we might want to sit down and negotiate and really try to be reasonable, there are some major companies that will play a scorched earth defense, which means you have to be knowledgeable about both the procedure and the underlying law so that you can properly educate your clients. So let's talk a little bit about the Americans with Disability Act. And again, these cases actually have, the cases are older as well. The principle is basically the same, although there have been major changes in the Act, and so I want to start from that standpoint, and then we'll come back to the cases. In both the EEOC and the federal government have announced changes as of 2009. The new ADAA went into effect, and what these changes were designed to do. So if you ever had a problem in this area, the case law has been seriously changed as a result of the extensive changes to the Act that came into effect on January 1st, 2009. Congress directed the EEOC to revise its regulations to conform to the Act. And here's the language I want to specifically read to you. These changes, these amendments, overturned several Supreme Court decisions. It's probably technically a little incorrect. They can't necessarily overturn them, but they can render them meaningless if the Act has changed as significantly as it did. And so the effect is the same. The language may not be as precise as lawyers we would want it to be. Because Congress believed that the court had interpreted the definition of disability too narrowly, resulting in a denial of protection for many individuals with impairments such as cancer, diabetes, or epilepsy. That the court, in their early review of this from 90 to 2009, the courts, at least as Congress felt, were overly restrictive of what should be considered a disability. And as it says here, Congress decided that disability should be interpreted in favor of broad coverage of individuals. And so what these changes make it significantly easier to establish that you have a disability, and that disability is a physical or mental impairment that substantially limits one or more major life activities, as you saw in the case. And now the modern trend, it says, just to get us all on the same page, it says, the principles provide that an impairment need not prevent or severely or significantly restrict performance of a major life activity to be considered disability, and that it has to be considered broadly to the maximum extent allowable under the law. And even an episodic disability such as epilepsy or cancer, if when active, are substantially limiting, they would count as well now. And so what we've got is some significant change from the standards as seen in some of these cases, and as a result of it, there's been a significant increase in the number of cases that have been filed under the Americans with Disability Act. So it's an act that not only covers individuals in employment situations, it's an access situation to places of public accommodation, and it's an act that has very, very broad coverage, and its use has significantly increased. Now, from a standpoint of both representing clients who are seeking accommodations or feel there's been violations of the ADA, or those that are defending these suits, because obviously there are a large number of companies that feel that this is expensive and severely limits their ability to conduct their business. There's a fair amount of conflict on both sides of this. So I want to start with the one that we obviously have conflict, or you generally have conflict about, is with respect to the Casey Martin case, which is really one of the early ones where the court wants to take a look at what it means to have a claim under the Act. And so let's talk about a little bit about why should the PGA have to do this at all, a professional golf tour? I mean, I might like to golf in the PGA and be able to ride a cart around while the rest of you walk, but I don't think that's likely to happen. How come well, first of all, does the PGA have to comply? I mean, is this like the NFL, the PGA, all the rest of them? They say, you know, listen, we have our rules, you comply with our rules or you're out. Or PGA, like everyone else, follows the law.
They're private with independent contractors being their golfers.
So those golfers are independent contractors. We're a private entity. We don't have to do anything. That's their position? Is that?
No.
Huh?
That was more or less their position.
That's their position in the case. I mean, the way that they were saying it.
They're independent contractors. We're a private entity.
They're not private.
We're not going to change our rules for you.
That's what they're saying. They're not private.
They're not. What do you mean they're not private, Sam?
They're not private. Public. It's a public place where it happens. It happens at a golf course. PGA is in the golf course, so it's a public area.
No, and it's not. It does happen at a golf course, and so this is a place where the public has the right of access.
Yes.
And so therefore, the fact that they may be a private entity is still going to be covered under the Act.
Correct.
As part of the Act, and the fact that they're a private actor doesn't mean private actors don't have to comply. We would have to comply here, even though we're a private actor.
Correct.
Right? And so does PGA get a slack cut because they're, the Professional Golfers Association? It's not, it's like the NFL. This is a sport. Sport shouldn't be affected by the ADA, should it? Yeah.
I do think the ruling was kind of narrow in that it was directed to this particular explain it. I don't know as the ruling was inclusive of like having to change the rules of the game so anybody who wanted to could use a card. So that was in the PGA's favor, I think. But I think the independent contractor thing worked against it. Like if, for example, in the NBA or the NFL, I think they're employees instead of independent contractors. So
I think the soccer, yeah, okay, go ahead, fair enough.
So in other words, I think that the fact that the golfers were all independent people that could easily qualify through the Q course or whatever, any public citizen could come in and try to get on the court. Like you couldn't do that in the NBA. Like a private citizen could try to just come on and qualify to get on the game or something. So that's where the difference was.
So they might not be a place of public accommodation, those teams?
Yes, because in other words, if they are completely private companies, private institutions with employees that are employed privately, and it's not open to anybody to qualify, they're less public.
And the Q school was?
Correct.
Okay. Well, do you think this is sort of a fundamental violation of the fairness? Poor Ash has to walk all these holes and he gets to ride. I mean, that seems like a competitive advantage to the game, doesn't it? Go ahead. One of you guys said both.
I don't think so. It's, reading this, I mean, obviously Casey Martin has a severe disability, and I think they pointed out in the case that, he might not be walking the same distance, but he's still walking an average of a mile every time he plays 18 rounds of golf. And he's probably suffering more fatigue and pain than anybody else out there. So, I mean, I think that's kind of that's what kind of makes it equal. I'm really surprised that this went the way it did with the PGA. I really thought an accommodation would have been made, but it sounded like they didn't even bother looking at like all his medical records and recommendations and whatnot.
Well, I do actually want to ask you about that too, because from a standpoint of settling the case and thinking about it, I mean, this doesn't seem like a good case for the PGA to choose to litigate to the very end either, because it doesn't make them look good. Or is it about the fundamental protection of the integrity, in essence, of the sport, our ability to make rules and enforce them against everyone? You had your hand up, and you were going to say something.
I was pretty much just going to say the same thing, just that his disability was making him just as fatigued, if not more, than the other players. So he didn't necessarily have to walk to get fatigued to affect his game.
And so no one believes that he's got an advantage here? Where everyone, Derek?
I'd say he does, and I think golf, more than anything, is one of those sports that are really like very historic. They're like trying to change golf rules. I mean, it's like the Bible to them. So I mean,
Slippery slope.
right, exactly. And so it's definitely an advantage. I mean, you have golfers walking full 18 holes, and he gets to drive around. That's I mean, and then that opens up the door to maybe somebody has a sprained ankle. Now he wants to ride in a golf cart too. It just opens up so many more things that they're going to have to deal with in the future. Or it's a fat person.
Right.
It could be John Davis.
I'm too drunk.
Yeah. So,
I don't know whether either of those would be considered a disability that's going to satisfy the standard here, guys.
Yeah, but I can see why they would litigate it so far, because it's going to open up so much more, and people are going to try to find a different type of hole to get in there with.
As a lawyer, do you talk to your client about that? Is that, okay, listen, we can litigate this as far as you'd like, but this is going to make you look really bad. Right? I mean, some of us must have read this, Sandy, and said, what a lousy organization to put this kid through this, Sandy.
Yeah, because, I mean, not for nothing, the ADA is individualized. So, I mean, you guys are saying that there's other people that, fat people, whatever, but if a fat person was fighting this, they'd lose. Because the ADA is specific to, it's an individualized thing. So just because he's going to win this case doesn't mean that everybody's going to be able to have a car.
And let me just back up. There's no doubt, none of us disagree here. This kid has a disability.
Yes.
And that certainly at the time, the way the act was written and interpreted, it would affect a major life activity, the ability to walk, right? I mean, so that's a given in this case, is the actual existence of the disability that does affect the major life activity.
And the medical records to back
and the records to back it up, and the ability otherwise, it would appear, I mean, we might disagree that whether he has the absolute ability to play the sport, because we'll play it and we'll see, but he certainly was a capable golfer in college, and certainly has certainly far more ability than probably any of us sitting in the room. But my guess is that at the end of the day, whether you get out of Q school and make the PGA or go back to bussing tables, it's probably a pretty fine line between a little bit of luck, right? Getting the right brakes, and certainly could be just that little bit of an edge. So this little bit of an edge could make the difference between whether he gets to go to PGA and some poor kid goes back and the other kid goes back and busts his tables.
That's what I was thinking. What if you were the next guy on the list that didn't get the cut? You know, would you think it was fair if you saw somebody using a cart and he beat you?
What?
You know, by one stroke or something.
It's all it takes, right? So
Yeah.
what about that? We don't care about that. We don't care about that guy?
No, I wouldn't. Because again, for me, what I get out of this is that this guy's condition, he's going to be tired, like, I don't know your name, I'm sorry, like Joe said, he's going to be tired just doing that 25% of the course walking. So it's the same, nothing's different for the competition.
Well, is that really true, though? Because, like, on some of the days, I'm going to play 36 holes.
Yeah.
And, geez, that cart, especially if it has one of those nice little tops, maybe a little bottle of water there, too, so that I put my legs up and drive and drink a little bit between holes. At some point, that's an advantage. 36 holes, I'm riding instead of walking. I mean,
Golf is tiresome anyway.
Huh?
I said golf is tiresome anyway. Just
oh, yeah, it looks brutal.
some of those courses, though. I mean, seriously, it's a long way. And I go and play 9 holes, and I'm like, shoot, I'm beat. I'm tired. But 18, that's serious. I mean, it's your profession, but at the end of the day, he has another skill to be able to. I'm treading very lightly here, because he doesn't necessarily have to play golf. You know, as his profession, he went to Stanford. So I'm willing to bet that he's got more going for him than just his ability to play golf.
Just out of curiosity, if it was basketball, your sport, and he had those legs that are like springy, you good with that too?
I'm not necessarily okay with that. I could get hurt off of that.
Well, you could get run over by the cart.
But that's a little different. There's certain parts of the greens that they can't drive that car.
Well, if Shaq ran into you, you could get hurt.
You're right.
No, so what?
He could get hurt.
So what's the difference, though? It's just this is your sport and we can't do that?
No, I just think it does provide just a little bit of an advantage.
Because right, you saw that in the last round of Olympics. They were concerned that he had carbon, the carbon legs, and they were concerned that there was a spring factor that would actually make him faster potentially, because they're lighter than real legs, and there's a potential spring factor that made him faster. And what if such a person wanted to play basketball? Because I could see, my guess is certainly could jump higher than me at that point, or if I had those types of legs, I think I could. So
I think now you're talking materially altering the game. I mean, a PGA competitor taking a cart because he doesn't want to get his leg amputated, but otherwise he can play the game just fine, compared to somebody with the bionic legs, if you will, jumping around playing basketball. I just think that material.
Sandy, even you agree with that? You're nodding your head.
It has to be a reasonable accommodation.
Oh, well, what's the accommodation? I'm just asking to be allowed to play the game.
Yeah, but
you don't have to do anything more than let me play. These are my legs now. Are you guys arguing I have an advantage because I don't have legs?
Perhaps.
Perhaps.
Science.
Does that? Are you?
Science is.
The way they make clothes nowadays, you could.
But are you comfortable with that argument? Because I do see it slightly differently as well. I'm not just trying to play devil's advocate, but so this person who served their country in Iraq or Afghanistan, lost their legs, and now but couldn't certainly shoot a ball and play, you're saying, no, I'm sorry, you have an unfair advantage because you don't have legs. I mean, I feel a little taken aback even voicing that argument. But that is the argument, right?
Now you make me feel bad.
No. I'm not trying to make you feel bad. I'm just trying to say, I mean, that is our argument, right? Is that the not having, these heavy tree trunk legs is going to make you a lot faster and make you jump higher, right? I mean, they look like there's a certain bounce to it that.
You're sympathizing the situation.
I am.
Because the veteran from Iraq coming home.
Yeah, I'm laying it in.
It's anyone. It's not just that amputee. It's anyone who's maybe lost their legs in a car accident, for example.
So do you think the amputee, who has the carbon fiber legs, should, the only accommodation I'm asking for is allow me to play the game with the legs I use on an everyday basis. In or out? Go ahead, Sunshine.
I think that you know how to test me.
They paid me
You
for
know,
this.
I think that the spring legs, like you're talking about, and I'm assuming it's the metal ones that.
Yeah.
That does change. It alters the game because then you have an advantage. You can jump higher. Whereas the golf course, he is more fatigued than an able-bodied person would be already because of his condition. So even if he's using the cart and another person is walking, he's already at a disadvantage.
But don't you think anything other than your existing legs or limbs is going to be, you're going to have to adapt to it, and it's got to be more difficult. I mean, nothing's ever going to work like my hand or my feet, so there's an adjustment, and I mean, you're telling me, we're arguing, you have an advantage by not having the limbs that God gave you, you're better off than me. Really? Because that's right, that is our argument here. Go ahead, Phoebe.
So would you say someone who wears glasses is more advantageous than those who don't? Like, you need the glasses to see. We don't all wear glasses, and there's some people who do. But I don't feel like I'm less advantaged because you wear glasses. Like, I can see fine.
What about that? You certainly wouldn't deny someone their eyeglasses to play basketball.
Well, what about a shooting sport where it was an open scope? And the guy says, I need glasses, but he really doesn't. And it helps them shoot better through the open scope. You know, it depends on the sport.
Well, you'd let them use glasses. Would you deny them the right to glasses? I mean, simple corrective lenses?
Or contacts?
Or contacts? Are you guys saying, oh, no.
I had my LASIK.
No, those, you can't argue. Are you guys now arguing that glasses would be an unreasonable accommodation?
No.
Well, it depends. Because
I see your argument there, Gary.
when I applied for my pilots on the Air Force, you couldn't wear glasses. So is that a discrimination?
Well, what do you guys think? Because that's right. At one point in time, if you wore corrective lenses, you weren't going to fly an aircraft.
Well, because you can put people's lives at risk
I think that
if
is
you're
total.
But it's still
flying.
discrimination.
If you drop your glasses.
But it's a
Actually, they're not.
It's not discrimination if you lose a contact lens with glasses come off, you crash the plane.
a little bit of a.
But there's a slippery slope argument is what I'm saying. Because in the golf course, where do you stop it? Is it just this one individual plaintiff, or is it a narrow decision? Or can now anybody who gets to decide who can use a cart or not? Or what about a bigger club?
Special clubs, yeah, because there's other golfers
'Cause you got
that
little
have
hands or something.
We're going to
tendinitis.
decide that the ADA.
All these
Of course,
other-
the ADA's rules, you guys can read them then, because the ADA is going to decide that for you. Nobody else is going to be able to make
It's
that
still a
decision.
person making decisions.
That
It's
is,
a slippery slope.
okay, hold on. That an otherwise qualified individual is entitled to a reasonable accommodation,
Correct.
right? So we get back to the question about otherwise qualified, and then we decide what's reasonable. So are we saying, just help to clarify, the person that needs glasses may not be qualified to be a pilot because they need glasses? Or, no, they're still qualified, because, if I were a pilot, I'd probably have a backup pair with me, just so they don't crash the plane when these break, right? I would think that would seem like a fair way to go. So, what do you got?
They give you the option to get corrective LASIK.
So I gotta get surgery? I have to undergo surgery
If you want to be a pilot.
if I want to be a pilot?
And you can't drink soda. They're not allowed to drink soda because it messes their brain cells. The synaptic.
Is that really true? That sounds like one of those Wikipedia things,
It's not bad. It's not bad.
Okay, you send me the link.
Seriously.
So, help me with, we're all comfortable with him getting accommodations for the most part. You're going to force a professional association to change their rules, what they see as fundamental rules of the contest, in order to provide an accommodation. But you won't do it for the basketball player. Am I correct?
No.
You do it for the basketball player too?
Yes.
Go ahead.
Rethinking my position with the basketball player with the blades, the legs. you know, as long as they weren't proven to, like, you know, give him an extra foot of leap, if it was equal, I actually think that would be okay. I think it would not be okay if suddenly they had to allow somebody in a wheelchair to go out there just because he could shoot. I think that would change the fundamental of the game.
So the wheelchair player doesn't get to play, but the carbon fiber legs will.
That's why they have the Paralympics, though. I mean,
That's what I'm saying. They need to be separate.
they have those certain leagues, though.
Right.
Well, you realize that
I know.
that logic at one point said, well, that's why there are women's sports.
Yeah, I do realize that.
And we let
I will break those barriers.
Well, but then why shouldn't the qualified disabled person have the right to compete against you able-bodied people if they think they can?
I don't say that they don't have the right.
Well, you just said the guy in the wheelchair can't play. Which you just said. When, again, by the way, when it was your sport, which I'm seeing a recurring theme here.
We have the person with the, for lack of better terms, the bionic legs. And they are perfectly able to do everything fine. It's just that they have these legs. Then sure, as long as you can take everything that goes with that game, because it is a physical sport. A wheelchair, on the other hand, with other able-bodied people, I think that can pose a problem with just the wheelchair alone, not the person themselves. I'm saying that the wheelchair could cause some sort
Cause a potential danger to the other contestants.
Yes, that's
How
what
would you
I'm saying.
decide how tall those big?
Yeah, I know. I wondered about that too, right? How do you said, well, if it's too much of an advantage, too much of a leap, then we can't. Because you're right. I could make the bigger I make the legs, the more spring I'm going to get. Plus, I'm going to be taller, right? So
I have a cousin that designs that stuff. I'll make a phone call.
well, but it's a fair point. Is that,
You know?
well, let's suppose they were no bigger than what your original legs were, but it would still, I'm sure there are engineers out there who could decide that depending on the tension, we're still going to give you a lot higher of a jump.
Right. So
And the material.
Yeah, how could you measure it doesn't give you an advantage? How can you measure?
Oh, I don't know, but I mean, I'm sure it can be determined in, you know, standard set. Have you?
Well, but by the way,
You see a 5'7" guy skying over 7-foot guys.
but by the way, this, at least part of this topic was the debate with respect to whether they should be allowed to compete in the Olympics because of the concern that it makes them faster. I don't know how you measured it. So now we're just saying, well, so now they can jump higher, which would seem like a possibility, but the other side was arguing they make them faster to run as well, and that didn't seem to deter the ability to compete in the Olympics. No one feels that sports, or maybe you do for basketball, that sports has the right, professional sports certainly, have the right to control the terms of engagement. That we don't all qualify for professional sports, very few actually do, and if they choose to establish their rules, they should be given the autonomy to do so. Oh no, they're...
Just as long as it's not a discriminatory reason.
As long as there's not a discriminatory reason or falls within a violation of one of the other various statutes. And this does. If you are a place of public accommodation, you must make accommodations for otherwise qualified people. And they did not.
I agree.
Right? What about your own profession? Are there certain basic things? Let's go to the doctor's case first, and then I'll convert it to your law school. McGinnis versus University of New Mexico School of Medicine. Because I'll be honest with you, I want my doctor to know chemistry and biology, and a little bit of math, but I'm really interested in my doctor knowing biology and chemistry. Are there? We'll come back to McGinnis, but are there sort of basic skills that a lawyer should possess that there can be no accommodation for? Or not? I mean, because do we, by the way, do we agree that your doctor should know anatomy and biology, and if they can't pass those tests, they shouldn't be a doctor?
That's right.
Okay. So, what about should a doctor have to function under stress?
Yes.
All of them? I mean, so you can't be a doctor if you have an anxiety disorder. No doctor for you.
Can't be a doctor. You can be a doctor.
Well, I'm asking you. What if someone says,
Well, yeah, difference between with the type of surgeon. If you're trying to be a surgeon, like I don't think that a neurosurgeon needs to have any type of anxiety at all. He needs to be cool, calm, and collected.
and young.
Right. Preferably single, but I'm saying.
So you would not have a problem with a doctor who has an anxiety disorder and says, I can't take all these tests on time or in the allotted time, but as long as I have, X number of time, I'll be fine with it, and I can get past these tests.
No.
Oh, no. So back to the question, so doctors can't have, there are some basic requisites of what you want your physicians to have, and anxiety disorders are off the table.
No.
No, they're not?
No.
So that wouldn't bother.
He just refused to
Does it
treat
interfere with his
Well,
job responsibility?
I guess the first part is, would they be otherwise qualified if that's it? What was this person's problem?
He had
Anxiety.
problems taking tests.
Test anxiety.
Right, people have
Test anxiety.
He says McGinnis has an anxiety disorder that manifests itself when he takes chemistry and mathematics tests. Mine was chemistry and calculus. That's always was my downfall with my anxiety disorder. I heard with you guys it's generally property and con law. Is that about right?
You're right. Most definitely.
Most definitely. So is that true? So I mean, back to my question is, well, geez, I think isn't it? Are you otherwise qualified then? Doesn't a doctor, doesn't a lawyer, and every lawyer, every doctor have to function with basically a pretty high level of stress that often surrounds their activities. So if you have an anxiety disorder, you're not otherwise qualified? Or, well, that's not my question.
No.
Stop talking. Huh?
What do you mean? If you have anxiety, you're not qualified? No, that's not true.
So even though you have an anxiety disorder,
Right?
you don't function well under stress,
Yeah.
it's okay to be a doctor or a lawyer.
It's not, you gotta
Yes,
treat it.
you don't have to
yes.
go into an operating room. You don't have to go into a courtroom.
dermatologist.
Well, okay, so you can be, my dermatologist deals with skin cancer and stuff, so that's still pretty important, isn't it? But
Mine just is a prescription for acne, that's
not a very stressful job. Oh, okay, so are there any disabilities that you would find disqualifying as a...
Yeah, narcolepsy.
And both?
Yes.
So you can't be a doctor or a lawyer if you have narcolepsy, which is you fall asleep at various times.
How are you gonna represent?
Well, he's operating, he falls asleep.
Huh?
It'll only be a minute.
Yeah. You
You
can
can't
fall
be
asleep
surgeon.
while operating, you can't be a surgeon.
That's the difference.
And you can be a lawyer?
You're a practitioner and
Right.
not ever be a
Not
surgeon.
be a surgeon.
So that does not disqualify you from
Right.
being.
So you could have narcolepsy and still be a doctor and a lawyer.
Yeah.
Yes.
You can do real estate law. Sit in the office of tax law.
So next time.
Tax law will love it.
Well, but wait a minute though. So when I get my medical license or my law license, they say, okay, Coyne, you can be anything but a trial lawyer. What else would be disqualifying? I don't know. Whatever else you want to make it.
Complex litigation, anything like that.
Because you can't fall asleep during that stuff, but everything else it's okay to fall asleep for. Is that true?
No.
As long as you were able to get
You
those
can't
grades
discriminate, so
together.
whether, you can't discriminate. If they can perform their job, then you can't discriminate.
Well, but that's, I guess, what I'm asking. Are you otherwise qualified if you aren't there certain conditions that are disqualifying? Listen, what was this one? I am not good, really, I'm not good at chemistry. Let's just take chemistry. Let's take chemistry and anatomy. Well, particularly, this manifests itself during chemistry and anatomy. I'll never pass these tests. Well, then you'll never be a lawyer. You'll never be a doctor.
No, but this case is different though, because
ahead.
he could have applied for an extended time in taking the test, and he didn't do that. And my thing with this case, and this is just personal, I think he was too prideful because he could have repeated that first year. He still had an option which he chose not to do. Instead, he chose to bring them to court. So he never asked for an extended time period to take the test, and then he just did not want to retake the first year. And he has all these other degrees anyway, so I think he was just being prideful baby is what he was doing. It's my
I wouldn't want a
opinion.
doctor that needed extended time for their tests either, and I didn't know about it.
Some doctors, you give them an extra time time, they get right in their zone. I
Not the
mean,
doctor I want to hire.
well, then you probably
That's
keep
why you got a choice.
disease.
That's right.
But how do I know?
But
Go on
that doesn't necessarily
recommendations.
mean that they're a bad doctor
Yes,
just because you need extra time. There are plenty of lawyers
That's
here,
right.
or people in this school, in fact, who need extra time. But that does not dictate whether or not they're going to be a great attorney.
It might
That,
not,
my
it
brother,
might,
is wrong.
but A doctor might be a little different. I don't know.
I would say so too.
Go on
I
recommendation.
Been
still
He's
think.
operating on me. I want to.
Well, let me ask you, does it make a difference if I have 3 hours to pass the anatomy exam versus 6 hours versus unlimited time?
That to me shows more fatigue is in the way.
Oh, so there's more fatigue? It's going to be harder if I'm given more
I think
time to
so.
pass that basic
I
anatomy
think so,
test?
because if you don't know it, you don't know it. You ain't gonna be able to pull it out anywhere. I think
Patrick's
you're
agreeing with
tired,
you.
you got more.
I don't think it's realistic.
When you ask for
3 hours, 6 hours. If I don't know it in an hour or two,
Yeah.
Pull it out nowhere.
Go ahead, Derek.
I kind of agree with you guys on one aspect, but there's a certain stress that comes under you when you take another like that 3-hour time frame. When you're like, hey, listen, like I need to like, you know, outline. I need to get ready. I need to get this done now. Like I know that there's like some people that do have a disability where they do need more time. But I mean, I think that there is a certain advantage given to that, where I mean, the stress is a factor in what you can remember and things that you forget during that stress. I forgot my student ID before I took a test once. It just happens. You know what I mean?
You didn't forget it. You couldn't remember.
Before the towards final, I forgot my student ID. I sat there for 5 minutes and I finally remembered it.
How'd the rest of the test go?
He's still here.
He's still here, that's
That was the
right.
last question on there, Professor.
What is your name?
Well, what about, let me raise the question, what about to the other, just like we asked about the other Q school person, what about the effect on the other pre-med students, the other medical school students, the other law students, when the field isn't the same here? We're competing with unequal standards. You are, aren't you? I'm getting 3, he's getting 6 to take the same test.
Well, you said 6, you doubled it automatically, and I think they give you a percentage, I don't think they doubled it
Okay,
automatically.
go to 3 to 4.5.
And then the other
50%.
thing is he's already operating at a disadvantage. And it's competitive out there anyway. Just because we all passed and I got extra time doesn't mean that I'm going to be successful out in the field or that you're not. Me passing with extended time doesn't mean that it's going to affect your abilities as a doctor, even though you passed.
Do you still have to pass the basic curriculum? Or can we get a waiver on, like,
No.
damn, that anatomy course, that anatomy, what? No what?
No
what?
You have.
No waiver. If you cannot pass the core curriculum or whatever they deem essential,
Find another job.
then you're not otherwise qualified.
Absolutely.
Right, exactly.
Because you guys did stress here that the fact is he could have retaken the courses, and it's biochemistry, which it's not sort of a field that one would think unrelated to medicine. You would think that goes to the core, at least in part, of being a doctor. Are there things that, with respect to being a lawyer, that if you can't do, you don't get to be a lawyer? I'll give you an example. I think it's hard to talk in the abstract. I've had people come to me at times and say, you know, listen, I'll bring you some information from my doctor. I can't function with the normal deadlines. I do not. My disability is I need extended time on deadlines.
Try telling that to a judge, though.
Well, that's the question, right? So if everyone's papers due Monday, I need 2 weeks after that Monday. What do you think? Oh, you think you're going there? Huh?
can I get your doctor's number?
Well, what I'm asking, and I guess Ash is asking the question, well, what would a court probably wouldn't recognize that. Right? There's some fundamental things that we do in our profession that make us lawyers, and I do happen to think one of them is meeting deadlines, because from both the client's and the court's perspective, if we don't, you're going to be in big trouble sooner rather than later.
My background is teaching people with executive functioning disorder, and this is young adults. If by this point you're here and you can't do that, then I agree, you shouldn't be here.
So we can adjust time, we can adjust study skills, we can do a lot of adjustments, but at the end of the day, to be otherwise qualified, you've got to meet what the core requirements would be, whether it's medicine or law or whatever.
Certainly.
So you're not waiving any of these courses.
No. Right.
No, you need to have a solid
You're not waiving the bar exam.
I think it's
I don't know, right? I'm sure some people would.
It's easy for us to say that because we don't have a disability. But, you know, if you are in that shoes, you want at least an accommodation. But I don't agree with the deadline and then the 2 weeks. Obviously, that's not reasonable. But something in the middle, I would agree to it. I don't know.
Would you want an orthopedic surgeon operating on you that never passed or took
No, I'm not talking about that.
Yeah, I mean,
No,
that's-
you have to pass the bar, you have to pass the medical
Yeah,
exam. I'm
But
just saying
you get
extra
extra
time to do certain things. Obviously, if
With
you...
extra time even with respect to deadlines?
Reasonable.
Well, no. No, an extra 2 weeks.
Not 2 weeks.
Oh.
Not 2
Maybe
weeks.
2
Well,
days.
an extra week?
No, 2 days maybe, but not 2 weeks.
But again,
But how do you deal with that when statute of limitations is, so that would be different for you?
well, no, then you have to change everything around you. Everything has to be changed.
What's a team?
So, go ahead, Carrie.
Yeah, I mean, this defies all logic to think that somebody should have extra time on a test. It's like, how do you test 2 people equally? If one gets more time and one doesn't, it's like, it's just beyond scope. Now, I would go like, if English was a second language, and that person is otherwise extremely intelligent, I might do something there. But otherwise, you gotta keep the playing field.
But that's not a disability, is it?
No, but if you were talking about extra time on a test, you know, for a doctor, not a lawyer, but for a doctor, especially a surgeon, I want to know that if they have the same qualifications. How do you know if they're the same qualified if one gets double the time or even any X percent time more than the other one? That means that one's probably less capable, in my opinion.
So would you give the bilingual students?
It's disability versus substantially limited.
Right.
So that's my argument. If you're, like you said, English second, because English is my 3rd language, and sometimes I take exams.
What was your second?
Portuguese and Spanish, and I grew up with both languages in our household, but I had to learn English when I was 7. So sometimes I take exams, and I wish I could just say, "Can I have more time?" Because if you have to reread and try to understand, but I think if you're limited and you need more time, why not? But disability, I think it's a necessity. Big time.
And just so you know, with the cases and all, I mean, that is in fact correct, is that from a standpoint of the foreign languages, that's not a disability, but when it's the disability is it takes me longer to process the information and then be able to make the analysis and express it, there are various language difficulties that's going to fall into, not spoken language or language difficulties in the second language, it's the processing ability that's affected, and under those circumstances that can be considered a disability that does affect the major life activity that we're talking about here. Not that it's not a similar, at times, obstacle, because I've had students who non-native languages in English tell me still, after all these years, you know, when I read it, I then process it, translate it in my other language, then I got to translate it back to English, and then I got to express it, and that's obviously a much more involved process than me, who was born and raised here, and the only language in our house ever spoken was English, that I don't have to function with trying to multiple different languages that I'm working with just to try and be able to then express it, and especially, frankly, in a timed exam, that has to be pressure filled at times. But even with that said, then, so with that said though, so then the extension of time for others, there will be people greatly affected as a result of that. But that's okay, because that gets us back to leveling the playing field because of that disability, that limiting condition that affects a major life activity. The law says that person gets an accommodation.
But see, I don't know how it affects other people. If you are taking the test and I'm disabled and you pass that test, and I pass that test even with a little extra time, and I'm already operating at a disadvantage, how is my extra time affecting
They got a B, you got a C. You good with that?
As long as I pass. And I don't have to retake the first year with Devlin, then I'm good.
We all want to spend as little time with Devlin as possible.
But this is
Go ahead.
just the same thing Kelly was saying. Like, if I have more time and I don't know, it's not going to come out of anywhere.
Right.
You have 3 hours and I have 4. And if I don't know it, then I don't know it. You're going to get an A and I'm going to get a C. Like, how am I?
And if I know it, and I just need more time to be able to overcome my disability, why aren't we back on the same page?
What if it's a real curve and you miss the cut and you get pushed down and you flunk?
But what is it you're saying? You would have not missed the cut if I had more time?
What if that
But why?
person didn't have more time? Somebody that did have more time was the one that pushed them down on the curve.
Well, but if the goal was that the person needs more time because they are otherwise qualified but have this major life activity that's affected.
And they got a D, and they push somebody else down to the F. And that course on a real curve.
But with this major life activity being affected, in order to just get back to where you are, where we start out at saying, okay, now we're relatively close to on equal footing taking that exam. How is that disadvantaging you as opposed to really crippling the student who started out at a disadvantage and you made no
If I
accommodation
got
for?
the F and I didn't get extra time.
But you didn't need the extra time because you don't have a disability. You're just a crappy student.
You know?
No, right? Right? You don't have a disability.
Anxiety, supposedly.
Huh?
Because the other person supposedly had anxiety.
Oh, okay. Well, wait a minute, though. And that's what we did, just so we're clear. We did this with the first case, and I wanted to make sure, let's separate out legitimate, acknowledged disabilities from those that somehow are conjured up, and we say, well, that's I don't really buy that. Because there are many, many, many people who have legitimate disabilities that obviously we should accommodate. And none of us, I don't think, would argue for the fakers and the malingerers that they need accommodation. They're just the people who take advantage.
I thought anxiety or depression now is considered because Social Security.
Whoa, wait a minute though. I'm not saying anxiety or depression is a fake illness at all, right? Listen, I had a case, and I'll never forget his testimony. The poor guy, he was treated horribly by his employer, and he had a panic attack at work at one point, just before he was constructively discharged, as we saw it. And he described it, and he was a big, strong guy, and they said, well, so he's being deposed. Describe what you felt. And he said it was like a bus hitting him in the chest and almost dropping him to his knees. The notion that he was not going to be allowed to leave that room, and they held him there for somewhere just short of 30 minutes. And when he said it, you could feel it. That has to be just as disabling virtually as me hitting him with the bat in the chest, because he was not faking it. I mean, I knew him well enough, and the testimony was sincere enough. He had trouble articulating it. So for those that have panic attacks or anxiety attacks, and we're not saying feigned, we're saying that can be established with medical evidence that the doctor would support. Well, that's got to be just as disabled. I mean, that's as disabling as, the little brace I have to wear for the next week or whatever, right? No? Go ahead.
I was just going to say, back to the bilingual student, how about just doing away with the extra time and issuing them a translated exam? An exam in their native tongue.
You go with that?
Yeah.
Oh, yeah. Have you read some of the exams? They have trouble expressing themselves in English. My professors are now going to give you Spanish exams and Farsi and all the rest of it.
Exactly. I speak out.
And Southern. Well, wait a minute, though. Okay.
Get a problem with that.
Oh, really? I'm surprised. Go ahead.
Yeah, because if they're like in the English-speaking manuals, and a doctor has to read fast or something, he has to be able to read the label on the packaging when he's opening up for surgery. It's in English, so you want to make sure they can read English fast, right? So.
Well, the language of our courts is English at this. From a lawyer's standpoint, it would worry me a little bit. The language of our courts is English.
So no accommodations at all?
Again, if you, like I said earlier, if you think that that person's eventually going to catch up, you know, like an English as a second language, then the person's otherwise extremely intelligent or whatever, you think they're going to do the job, and they're going to pass
They have to be extremely intelligent. They can't just be intelligent because, you know, I mean, again, we're making them push that bigger rock up. The rest of us are.
Medical boards, I think there's time limits when you can take them. If you have to take, like, I don't know about the bar exam, you could probably stretch it out several years, but you got to do law school in 3 or 4 years, so you got to catch up in that time period. So, you know, you're going to have to be probably a little bit more intelligent than the English speaker, maybe, to catch up.
There's some parts of Texas that I've been to and I felt like a stranger because I couldn't speak anything. And we're an English-speaking country, but I'm telling you, when I went into that part of Texas, I needed to go back around and go another way because I clearly was the foreigner at that point, and I'm just being for real. So, you know, I hear what you're saying, and I hear what you're saying as well. In some instances, maybe that would be a better thing, you know, because to make accommodations, because it shows that we're wanting people. It shows that we're open-minded. But then I can understand where you're coming from as well. Like, you're here, you need to learn what we need to learn, and I get it.
Not everybody gets to be a doctor. So
I get it.
Pick a different profession.
Well, and there's cases that, well, this case said that. There's other cases that say not everyone gets to be a doctor, not everyone gets to be a lawyer. You've got to show that you're otherwise qualified, but you also have to meet the basic requirements of those institutions. And the courses he wanted to skip or sort of work around were just not ones that you can skip or work around.
They even say in here that he pursues all these degrees in the subjects that trigger his anxiety. And in the past, he's been able to mitigate his study habits. So, like, what's changed all of a sudden?
He doesn't want to do it anymore.
I think he failed the test.
Plus, it probably went up a notch, and medical school might have been a little more difficult.
Let's talk about Toyota Motor Manufacturing versus Ella Williams. Well, I think this is probably one of them that in part generated Congress's actions in amending the statute. Roberts looks like he argued this case, as you can see it, for Toyota. As the court saw it, she didn't have a disability because she could work. She just couldn't keep her arms up like this for 8 hours of the day. Who the hell could? Who would want to? But from Toyota's standpoint, if I can't have her do that, Ash doesn't want to do it either, right? From the standpoint of managing my shop, I'll do the 3 easy ones. I don't want to do that one. Well, when given a choice, wouldn't that be everyone's alternative? Or, geez, how do you say this woman, when you read it, wasn't disabled and didn't deserve an accommodation when the medical evidence sure indicates that this is not feigned. She had problems, pain in her neck and shoulders, and shoulder blades. Should Toyota have made accommodations for her?
This is one of the cases that they were going to render meaningless at this point.
Right. Why do you say that? Go ahead.
Because carpal tunnel now is a legitimate disability.
Yeah, I think it's actually within the EEOC. And let me talk briefly about the EEOC. I think it's specifically one of the ones mentioned in the regulations now. And EEOC is Equal Employment Opportunity Commission. And again, for a lot of these types of claims, they may well start out either at EEOC, Equal Employment Opportunity Commission, or the Mass Commission Against Discrimination. You may file your claims there and may be required to. And certainly if EEOC decides to take it and run with it, that helps you. But oftentimes, they will then investigate and make some findings. And certainly if it supports you, it is usually very, very helpful. And in fact here, it was a prerequisite to sue. They gave her a right to sue letter, and then she filed suit. Sometimes in claims of discrimination and the like, you must, in essence, exhaust your administrative remedies before you can file suit. So if you jump to court, having not gone to EEOC or MCAD, your case is untimely. You are not in the right place, and your case will be dismissed. So you've got to start to think about this as you look at the various statutes that might be involved and make a determination whether the claim has to be presented to the agency at first. In Massachusetts, most of these claims have to be presented to the MCAD first. Once presented, you can actually dismiss it shortly thereafter, but you've got to give them an opportunity to look at it. The problem with our the MCAD in here is that it's extremely slow. And so you don't want to wait forever for them to do their whole process. So oftentimes you'll present it and then dismiss it and then file suit. Sometimes you'll give them the opportunity to investigate it and even have a hearing, but frankly, that could take you 2.5, 3 years. And then the court process is going to take you about the same. And so now we're 5 years down the road. So the agencies sometimes are slower, and so you want to take that into consideration as to whether you want them to be able to work it, and especially, and I'm sure our agency isn't the only one like this, but if you don't stay in contact with them and follow up, your claim may just well sit on somewhere without getting much activity. And so in Mass it becomes problematic. The EEOC is much more timely, but it's again something, it's oftentimes a prerequisite, and you've got to think about satisfying the condition, but at the same point you want to keep advancing your case, because as a regular matter, cases are going to settle shortly before trial. If activity isn't taking place, there's no incentive for the defendant to try and be reasonable. And meanwhile, your plaintiff is potentially out of work, out of money, and at some point they fold because they've got no money and they can't wait forever. So that's why, from the standpoint of plaintiffs, we push, defendants delay, and I was taught early on, you put your blinders on and you keep moving it towards trial as fast as you can, which still can take far too long. But that's the way you approach it from the plaintiff's perspective, with the expectation then that the closer we get to trial, the more realistic and reasonable people will be. And that's, over 30 years, I've found that that's 110% true. You think carpal tunnel would be covered now? She certainly, while she can work some, this is a significantly limiting physical condition that deserves some level of accommodation.
Yes.
You do. Anyone not? Go ahead, why?
Well, two things. First of all, I think Toyota made as many accommodations as it possibly physically could within the corporation and the job. Number one, I mean, she got to the point where all she was doing was inspecting. That was like nothing, It seemed to me that this person was just shopping for doctors to give her all these different diagnoses anyways, perhaps. But in the end, how can you force a manufacturer to give this lady a job when there's no jobs in the whole plant for her to do? If there's nothing she can do, how can you keep employing her?
Where did you get from this case that there was nothing she can do? I got from the case that the one she couldn't do, which I would think would be hard for all of us to do, is to keep her arms up over her head for many, many hours during the day.
2 out of 4 things, I think it was. There was
Yep.
2 activities out of the 4 activities she could still do.
But doesn't that mean she could do 2?
Yeah, but then but even though she was doing that, the way I read it, even when she was just doing the 2 of the 4, she was still missing work. I just got the impression this lady did not want to work.
No, it says respondent requested that petitioner accommodate her medical conditions by allowing her to return to doing only her original 2 jobs in QCIO, which respondent claims she could still perform without difficulty.
Yeah, but then she didn't though. She still missed work.
Well, they just terminated her after that, saying that
because she was missing work.
That she had poor attendance.
Yeah, so
That's because they're.
I mean, I'm looking at this lady that can do all
They didn't bring her back for the 2.
Yeah.
No, they did it all 4, and she got sick.
Right.
No?
She did all 4. She had
Yeah,
to do all
could be,
4 jobs.
And they're the ones that decided that it was going to be necessary to rotate all of them through all 4 jobs.
Right.
But isn't that their right, though, too? So, because what am I supposed to do? Tell just the younger, more able-bodied employees, okay, you guys and women do those 4 jobs. They said, this job stinks. Aren't they? I mean, because then I'm going to lose the younger employees as well, potentially. Because this would sound like a job no one wants to do for multiple hours a day, right?
But
So they're good paying jobs for unskilled workers essentially, you know, so it's a lot of people probably jumping at it.
But the bigger problem is when other people in the plant see what she's doing, they could all copycat.
What about that? Again, from the standpoint of running my shop, if I can't make the rules as to what people are required to do, who the hell's in charge here? Go ahead, what?
I said her issue was substantiated, she had a medical note, so if everyone wants to do that, like, they all have to have a medical, I mean, I don't think doctors would just give out medical notes for nothing.
They get paid to do that.
So with
Incentive to do it.
So with a medical note and support, I mean, we may need medical records, we may need, I mean, either the person is or isn't disabled. And we may be skeptical of the data, but you should examine the data, and if it's there, they get accommodations. Go ahead.
Doctors give people antibiotics for viruses. Who are we trying to kid here? To make them happy and make money. They have incentive to give the doctors note. There's no loss with it.
But that theory would be we'll never trust a doctor's note on any ADA claims.
Got to back it up with something else, I guess, like an expert, like an independent, like when you go to a medical claim, you got your doctor to look at the patient, right?
Okay, but when we say, and just so you understand how these work, when they say, okay, we're going to send you for an independent medical evaluation, if I'm traveler's insurance and I send 1,000 people to ASH every year for independent medical examinations.
I'll give you what you want.
Yeah, Ash knows. Ash knows if he wants 1,000 next year, 990 of them better be able-bodied and ready to return to work. I mean,
that's making my point, though. See, doctors can do whatever they want.
Oh, so but you and Justice Roberts want me to be able to, as Toyota, send them for independent medical exams, and when the doctor says no, nothing wrong. You know, it's the old Army physical things, you know, let's check his hearing, they ring a gun right next to his ear, oh, he can hear. So as long as he's not walking in there with the carbon fiber legs, he's okay.
If it's specific to that job, right? In other words, carpal tunnel, she probably can't do the repetitive nature like that stuff. But then when she was expecting paint jobs, a little different.
Well, Sandy says, she thinks in part, and I agree with her, I think you said it, I don't want to put words in your mouth if you didn't, that this is perhaps one of the cases that Congress looked at and said, okay, this isn't broad now. You guys have really, in the courts, have gotten overly restrictive with what should constitute a limiting activity of a major physical.
The thing is, you got to be able to do the essential functions of the job with limited accommodation. You can't just cut out parts of the job because they're essential.
What about that? I mean, her accommodation is, I don't want to do that anymore, right? That's not, give me a little ladder, give me a chair, let me sit down periodically. She's saying, no, not that one. I'm not picking up the 500-pound slabs of concrete anymore. That can be Pat and Derek can. So, I mean, that's, she's not otherwise qualified then, is she?
She is not. Right.
She is not.
I feel like she was, she tried to get some workman's compensation, and she went to FML, and she just exhausted all her options. And so she's like, let me sue these guys to see if I can get any more money. That's what I read.
Well, but let me ask you, let me flip that around. So you guys wouldn't, representing your client, go get workers' comp and then take a look at,
Shows you were trying.
So you would be looking to fill your pockets and your client's pockets as well.
I got 8 too.
And listen, and listen, these, by the way, what we haven't talked about is your ADA claims, your claims of discrimination, not only are likely to award your client significant damages, but they're going to pay your attorney's fees as well, because attorney's fees are part of the award if you are a successful litigant, which means you have to go to judgment. Not settled, judgment. So if you do end up having to try the case, you could find that your fee will be paid as well. which obviously matters to you. The last case here is just the Eeo C Case versus Waffle House. And I like this case because I wanted you to recognize that, other than that the Waffle House is Darius's favorite restaurant ever. And I have been there, and I do not understand it at all.
Delicious at 2 a.m.
Yeah, maybe at 2 or 3 a.m. That's about it.
At 8 a.m.
No, it isn't.
She goes to, it's awesome. I have to take you to my neck of the woods.
Yeah, okay, because the ones he's taking me to aren't even clean.
Real pork chop.
Oh, God.
So, at any rate,
Yes, ma'am.
and this is becoming an increasing problem within his initial employment agreement. He agreed to all disputes being settled by binding arbitration. And the trend is, and this is 10 years old at this point. The trend is in any employer that does have an employment contract of this sort, it's going to be a choice of law provision in there. There's going to be likely arbitration because that does away with your jury trial rights. It also provides the business with a speedy resolution of it. Oftentimes, though, this is not advantageous to the employee. I tell the story when, this is a dozen years ago now, but when my son went looking for a summer job. He came back from Circuit City, which was like a Best Buy then, with an employment contract this thick for a $7.50 an hour summer job. I looked at it because it was interesting to look at, and it had a waiver of God knows how many different claims and a required arbitration. And I'm just thinking, how many people just sign the damn thing and start work? But the fact is that an employee can, as this case says, but that you can waive or their right to go to court and agree to arbitrate their claims. And in fact, if you look at the back part of this case, there is a Federal Arbitration Act which strongly encourages the enforcement of such provisions. You'd almost think that the federal framework would encourage court access and due process, and instead there's a federal statute that strongly favors the enforcement of these types of provisions. But even with these provisions, it can't preclude the EEOC from proceeding as it would want to, because the EEOC's rights are independent of the employee. But I thought it was a very good case from the standpoint of getting you to recognize the interaction both between the employee's rights and what EEOC may do. But oftentimes it's the employee who brings the claims to EEOC that gets them to move forward at any rate. So there's other alternative avenues to pursue on behalf of the employee, and these EEOC and the MCAD are a couple of the more significant ones. And EEOC oftentimes will investigate. It's not an adjudicatory process, but will make an investigation, interview witnesses, and then issue a report. And that report can be quite beneficial then when you move forward into court to try and pursue your rights. Huh?
I said, they'll try mediation first. If you get it resolved, then you go to court.
So, I will see you next time. Oh, sure. Thank you.
I know.